join me in welcoming my dear friend, Judge Kevin Smith.
Well, I'm humbled, Ron. I wasn't expecting that, but thank you very much. And thank you for the opportunity to talk about what I think is a very important issue. And the bottom line is we have a Constitution for a reason, and it's to limit the federal government and keep it off our back. I mean, that's the ultimate goal of the Constitution. So what I'm going to share with you today, obviously there's been a push for a convention of the states. In fact, what I'm presenting basically are the contents of a paper that I published with Regent Law Review on the Convention of the States. The title is Roadmap for Convention of the States. So really there's two groups here. You don't all have to be mad at me. The fact of the matter is, for people who are pro-Convention of States, you know, what I present in the paper and what I'm going to present today is a way to ensure that we don't have a runaway convention, as they say. It's also a way to understand what could happen if we do this the wrong way. So let's go ahead and dive into it. But first, if you have any desire, if you have access to Lexis or Westlaw, this is the actual reference, the actual citation for the article. 35 Regent Law Review 1, page 135, that's spring of 2023. It was just published in the most recent issue. Also, if you would like me to send you a copy of the PDF, the Law Review graciously sent me the PDF copy that includes all the footnotes and all the sources. I'm more than happy to do that, so just give me your email at the end of this and I'll send that on to you. So let's talk about it. First of all, the goals that I have today, the goals to kind of inform you of what's going on. First of all, we're going to discuss the process for calling a convention of the states. Also discuss a brief history of successful and not so successful amending of the Constitution. We'll talk a little bit about the current resolution, the one that our legislature did not vote in favor of the most recent last legislative session. I'll also discuss convention objectives that will protect our freedoms and not risk the runaway convention that we hear people talk about, and also procedures that the states and not Congress should implement. And I'll also discuss the possible repercussions if this current resolution doesn't include procedures for the convention itself. So let's dive into it. First of all, and I'm not going to read this whole thing, it's Article 5 of the Constitution. It basically discussed the process for amending the Constitution, and there are two. One is for Congress to vote. Now, let me just kind of throw this out there. This is kind of a rhetorical question. Does anyone think Congress has ever supported an amendment to the Constitution that limited its power? Anyone? Has that ever happened? Correct answer. They haven't. So literally, if we want to limit Congress's power or the Supreme Court's power, there's only one way to do it, and that's through the amendment process. As far as that process, again, the top of this is the most important. It is not the states that actually seat the convention. It is Congress. The very top of Article 5, whether it's the states that vote on it, 2/3 of the states vote on a resolution, or whether it's Congress, 2/3 of both houses of Congress vote on the resolution. It is ultimately Congress that calls the convention and seats the convention. And again, this discusses those, and I'm going to kind of fast forward through this because I would like to take questions, and there's a lot of material here. Now, as far as the congressional method, we've amended under the first mode multiple times. And again, as a reminder, the way those amendments make it to the states for ratification, 2/3 of Congress, both houses of Congress must pass. From 1789 to January 3rd, 2019, Congress had proposed 11,848 amendments. Congress submitted just 33 of those amendments to the states for ratification, and the states have ratified 27 amendments. Now, this number is a little bit deceptive because remember, the first 10 amendments are in the Bill of Rights, so really that was one. And then you had another 17 that were actually ratified. And one of them, see if anybody knows the answer to this, one of them was repealed. Anybody know which one that was? Prohibition, exactly. One of them was repealed. In fact, back to my original premise that Congress never votes to restrain its power, that one time they did. They literally restrained their own power, and that's the only time they did. And again, except for the very first convention, we've never amended the Constitution under a convention of the states. Now here's a quote I want to throw out, and again, I don't want to upset anybody, I just want to provide you some information. But this is the actual resolution. Our convention would only allow the states to discuss, this is a quote from the national side, amendments that limit the power and jurisdiction of the federal government, impose fiscal restraints, and place term limits on federal officials. Now to be clear, this sounds like a very worthy goal and a worthy objective, but I want to share with you some of the issues that could happen if we don't make it a little more specific. And again, the title of the paper is Roadmap to a Convention of the States. It's not opposition, it's to hopefully address concerns that both sides may have. Now, here are the issues. One, limit the power and jurisdiction of the federal government. That's the primary prong that would, for example, rein in some of the federal legislation that we've had that has infringed on the rights of states. Two, impose fiscal restraints. Three, impose term limits on federal officials. Now I'm going to throw this out there. This is a rhetorical question. And to be clear, if I can't present all these slides, I will make the paper available to anybody who wants to read it. What does the Constitution by its nature do? Anybody except that table back there, because I've already talked about this with them. What by its nature does the Constitution do? Anyone have a thought?
It delegates limited enumerated authority to the federal government.
Okay, there you go. So, could you argue that it limits the power and the jurisdiction of the federal government?
Absolutely.
That's what it does. That's what the Constitution does. And it also, again, it limits the power and then it limits the jurisdiction to matters of common concern to all the states. In other words, this particular part of the resolution, limit the power and jurisdiction of the federal government, is effectively, or could be interpreted as such, a mandate to revise the Constitution from top to bottom. Now, there's an analogy that I like to use. It's kind of an interesting analogy, I hope. If you have a vehicle that has a governor on it that limits its speed at 50 miles an hour, and you still want a limit, but you want a higher limit, and you have your auto dealer change that limit to 100 miles an hour, you're still limiting the power of that vehicle, but you're extending the limit to a higher level. And that's the problem. Again, everybody in this room, I like, and I believe we share most of these views similarly. I'm not sure who's going to be at the convention. That's my concern. My concern is how they will interpret that mandate. In fact, here's an interesting quote, and this is a quote that's actually on the National Convention of States site. A constitutional convention is a horrible idea, and this is from Justice Antonin Scalia. This is not a good century to write a constitution. And the whole purpose of that, in order to put it into context, was that the typical response to that is the convention's purpose is not to rewrite the Constitution, it's to propose amendments. The problem is you could propose one amendment that totally negates the first 10, which are the Bill of Rights. It could happen, and it is possible. Now, as far as the roadmap, here's the roadmap, and this is really what I want to focus on. Hopefully I have time to do this. First of all, rein in the convention with specificity. That's all, specificity, so we can't rewrite the parts that we want to keep, such as the Bill of Rights. Imagine, for example, under the Second Amendment, what if an amendment was proposed that limited the power of the federal government to only regulate firearms that are owned by individuals and not regulate firearms that are held by the military? That could theoretically happen. And we have at least two former Supreme Court justices, Ruth Bader Ginsburg and John Paul Stevens, that have proposed that. So that's an example of what could potentially happen if we don't rein it in with specificity. Also, to expressly define procedures so Congress and the courts can't interfere with the Constitution's mandates. In fact, that's the other part of the Article 5, which is very ambiguous. It doesn't say, although it says Congress calls the convention, it doesn't say who writes the procedures for the convention. So imagine Congress adopting some, without specifics, some very egregious procedures, and also some possible ways to restrain what the convention discusses, who do you think will review whether what Congress did is constitutional? Come on. The Supreme Court. Can you imagine Congress setting the procedures and then the Supreme Court, which is part of our problem, ruling on whether those procedures are proper? That's a pretty scary scenario that I really think we should avoid. Also, again, we should educate citizens on where we started and where we've arrived as far as expanding, and I'll just say it, the growing behemoth of the federal government. So first of all, my first proposal on the roadmap is interstate commerce. In fact, most of the areas where our federal government has gone off the rails is through interstate commerce. In fact, just to give you a brief history on this, our founders believed that there were 4 parts of our economy. 1 is agriculture, 2 manufacturing, 3 commerce, and 4 maritime, or shipping on the high seas and navigable waters. Only when the first 2, that's agriculture and manufacturing, were sold did they become commerce. And 3, only when those first 2 were sold, then transported across state lines, did they constitute interstate commerce. Now, in fact, this is the actual article. The Constitution empowers Congress to regulate commerce with foreign nations and among the several states. And it's this particular prong of the Commerce Clause that has been used for pretty much every expansion of the federal government, with the exception of the next issue I'll talk about, since the late 1930s. It is the Commerce Clause. So almost everything you do basically has been defined as affecting interstate commerce. In fact, until 1937, the court honored the founders' vision of interstate commerce. And it was the 4 horsemen of the apocalypse. You know, would you believe liberals gave a negative term to some good people? The 4 horsemen of the apocalypse, Justices Pierce Butler, James McReynolds, George Sutherland, and Willis Van Devanter, along with Justice Owen Roberts, consistently struck down Franklin Delano Roosevelt's efforts to expand federal Commerce Clause powers. In fact, he threatened to water them down with the Judicial Reform Act of 1937. Basically, to summarize, he basically told them that he was going to appoint a new justice every year for 6 years until he controlled the courts. So that's how the executive branch basically tried to cram down his views, and it worked. In fact, any conspiracy theorists here? Within a period of about 6 months, 3 of the 9 justices either retired or died. And then FDR replaced all 3 of them. And guess what? He controlled the court. So it's kind of an interesting fact in our past. Here's the case. Here's the case that this newly restructured pro-FDR court came up with. It was Wickard v. Filburn. And to briefly summarize, a private landowner owned 23 acres of wheat for personal consumption. He used it to feed his own cattle, feed his own family, and he sold it locally to basically pay the bills for his family. FDR's Agricultural Adjustment Act of 1938 restricted how many crops that a farmer could grow. And the court held that in the aggregate, and just listen to this logic, if every person in the United States grew 23 acres of wheat, that would have a dramatic impact on the price of wheat. Therefore, it's interstate commerce. That was how the Supreme Court ruled. And you can imagine just about anything you can think of in the aggregate would have an impact. And that's basically where we are today, because after that decision, which I believe it was issued in 1942, after that decision, as long as Congress discussed the impact on interstate commerce, the legislation has been upheld. In fact, to give an example, I can barely read this. This is an example of some of the issues that, man, I'm getting old. Some issues that guns and gun accessories, drugs, illegal and otherwise, labor, cattle, automobiles and automobile accessories, wetlands, power generation, banking, securities transactions, oil products, railroads. You get the idea, pretty much everything. In fact, the only decision that's come out by the Supreme Court that tried to rein in this power was the Lopez decision. And in that case, they were making an argument that if you possessed a firearm within 1,000 feet of the school, that disrupted the education environment, therefore it impacted interstate commerce. Now, it didn't say you have to use that gun within 1,000 feet of the school. Mere possession of a gun within 1,000 feet of a school impacted interstate commerce. That decision was struck down, that law. Now, here's the proposed amendment for this particular issue. And again, if you go back and look and read the paper, you'll see some of the other cases that it cites. But of all the abuses of power, it is the Commerce Clause that has resulted in the greatest expansion of the federal government's power. My proposed amendment would limit the Commerce Clause power to the regulation of 1, transactions of the sale of goods that are transported across state lines. That's the Founding Fathers' original vision. And 2, federal highways and transportation systems that are used to transport those goods across state lines. That's it. And specifically, the amendment should overrule all Supreme Court cases that apply the substantially affect test to the law, and that includes the Wickard v. Filburn decision. Now, the other issue that we need to consider is Article 1, Section 8. And I'll just summarize. This is referred to as the tax and spend power. In other words, the federal government can't come into Kansas and say, your speed limits are 55 miles an hour. Can't come into Kansas and just automatically make it illegal to drive a motorcycle without a helmet, things of that nature. The only way they can get away with that, even though they can't regulate for the health, safety and welfare of individual state citizens, the way they can get away with it is the tax and spend power. They can tax and spend funds for the health and general welfare of the citizens. So in other words, they can basically tell the state of Kansas, we have $100 million that we're going to give you if you insert the blank line here. They can literally force a state to do these things in order for them to actually get that money. And here's some examples. That's how we got mandatory seatbelt laws. That's how we got mandatory motorcycle helmet laws. And thank goodness, I know the legislators that are here aren't old enough to be on the original legislature that passed this, but we've resisted that temptation. So whatever highway money out there that's out there attached to motorcycle helmet laws, our legislatures have stood up for freedom for the citizens. Mandatory COVID vaccination policies, as well as the lockdowns, the 55-mile-an-hour speed limit in the late 70s, and uniform unemployment compensation laws. All of these are a direct result of the federal government tying strings to money that we're entitled to, that we paid into the federal tax system. And the proposed amendment to roll that back is to eliminate the tax and spend for the general welfare power. Only if the taxing and spending is necessary and proper for the exercise of other enumerated powers, such as the treaty power, such as the power to declare war, things of that nature, may it be used. Otherwise, Congress should be barred from attaching strings to the receipt of federal funds. Shouldn't that be up to our senators and our legislators? If we vote somebody into office, they should be fighting to bring back and repatriate those funds that have been taken away from the Kansans and instead taken to Washington and then redistributed to other places. Our legislators should fight for that and not have strings attached to that. Now, this is the big one. And I'm glad Chuck's here because I'm sure he'll agree with this. This is the big one. The bottom line is, when our founding fathers originally drafted and the states ratified the Constitution, they had this vision of separation of powers on a multitude of levels. Obviously, the most obvious one is you have an executive, you have a legislature, and you have a judicial branch. But you also have, through a republic, different sovereigns. You've got sovereign states, 50 different governments, and you have the central federal government that regulates on common issues. But the problem is places like New York, California, other highly populous states would run roughshod over Kansas if it was all about majority rule. So they built a protection, another check and balance in there, and that was the Senate. The Senate, where number one, each state gets the same number of senators. And again, it's a co-equal branch of the legislative branch. But the most important part is, when they originally envisioned it, it was the state legislatures that selected their senators. And guess what would happen if a senator went off the rails and was threatening or did vote for something that was against his own state's interest? Guess what Susan Humphreys would do? Boot him and replace him with the senator that cared. In fact, just to give you kind of a historical perspective, what's real interesting is the 17th Amendment was ratified shortly after and proposed shortly after the 16th Amendment. The 16th Amendment legalized income taxes. Do you think for a second that if the 17th Amendment hadn't been ratified, that Congress would have been able to ratchet up income taxes like they've done? Now, we already have California that has a state income tax of 13%, which I don't see how they get away with that, given the fact that there's a federal tax. But imagine how much more our legislatures in Topeka would be able to do if instead of having a 40% federal income tax, it was only 5 or 10%, and we could have I'm not supporting this, by the way, but we could have let's say a 10 to 15% state income tax. Imagine how much more they could do for the citizens of Kansas, for mental health issues, all these things, a lot. So the bottom line is, and this is the tough one. In fact, to give you kind of a brief history, I've got a little bit of time here, kind of a brief history. The big issue with this amendment is that, first of all, give me a second. Well, I'm just going to move on. I don't want to lose time, and it looks like we'll have time for questions. So I see some people that are gritting their teeth. So hopefully we'll get to that. So the proposed amendment here is, in order to make sure states have the ability to check the federal government, and it's not a matter of the majority rules, is to repeal the 17th Amendment and reinstate the original method of selection and retention of senators. And that is, the state legislators select their senators, and then they have the ability at the end of their 6-year term to replace them with new ones if they vote against things of state interest. Now, we've actually had some senators that have done that, right? Can you imagine what would happen if our legislatures had the right to pick up the phone and say, don't vote for this? It would have a huge impact. Now, here's the other one, and I love this. I found a few Ronald Reagan quotes on this. The feds are spending money like drunken sailors. And I'm going to add to this. Ronald Reagan added to this and said it's not really accurate because drunken sailors only spend their own money, which is kind of interesting. In 1980, the federal debt was $908 million with a debt to gross national product ratio of 32%. By the end of 2021, the debt increased exponentially to more than $29 trillion. It's around 31, 32 now. And that was just 2 years ago, with a debt to GDP ratio of 124%. Here's the proposed amendment. A balanced budget is mandatory except in times of emergencies, and the convention should strictly define what constitutes an emergency so Congress cannot weasel out of their fiscal responsibility. Now, here's the other one, and a few of my attorney colleagues take issue with this, but I'm going to talk about this anyway. We talk about checks and balances, that you have 3 branches of the government, and they're all supposed to make sure the other branches, the co-equal branches, stay within the constitutionally mandated limits. That's what we're supposed to have. But there's a case, Marbury v. Madison, that changed that. It was a very early case. In that particular case, the issue was whether the current president had to seat an appointee from a prior administration. And the Supreme Court found that they didn't, because the way Congress was able to pass this law was they effectively gave the Supreme Court extra power to do that. And the Supreme Court came around, and it sounds like a good thing. The Supreme Court returned its decision and said, you can't increase the power that we have because it's unconstitutional. You have to have an amendment to do that. But even though that sounds like a good thing, they also pointed out that we also have the power to review everything Congress does, everything the president does, and make a determination as to whether it's constitutional. In other words, the Supreme Court became the very last say when it came to constitutional issues. Does anybody, I mean, again, right now it looks like some things are getting rolled back, but long term, does anybody here want the Supreme Court, 9 unelected people wearing robes? Does anybody want them having the final say on constitutional issues? And here's the proposal, and this is the one that's gotten me kind of in some trouble with some of my colleagues. Congress shall have the power through supermajority vote of both houses. That's 2/3. Same number you need in order to propose an amendment or pass an amendment to send it to the states for ratification, to reverse any Supreme Court decision it finds to be unconstitutional or beyond the court's authority. Any decision. That's the only way. You know, right now the president, in effect, has the ability to check through the veto. Congress has the ability to overrule his veto, but guess what? Nobody has the ability to check the Supreme Court. Let me just see a show of hands. This is my favorite one. Let me see a show of hands. Who thinks this is a good idea? This one right here. Bottom line is the ability of Congress to reverse Supreme Court decisions. There we go. So there's one thing we can all agree on, right? Now the other one, and this is another one I think we're probably going to agree on too, senators and representatives, and let me just say, when it comes to the balanced budget amendment, that's in the current resolution. When it comes to term limits, that's also in the current resolution. Those other 3 things that I added, those are to specify that other part. That's the limit in power and jurisdiction of the federal government. That's really the only one in my humble view that needs to be more clarified. Now let's talk about this. This is just shocking. The second point is what really stood out for me. The average increase in net worth in the top 100 of House of Representatives was 114% per year. Every year they double their net worth. Imagine that. You think they're not getting rich the longer they stay in office? Of course they are. Now, this is a nonpartisan issue. Again, of the top 100, 56 are Republicans and 43 are Democrats, and 1 is an independent. In fact, I think the big issue here is the longer they're in, the more they realize they can make if they stay in. Look at the lengths of service. Robert C. Byrd, 51 years. Daniel Inouye, 49 years. Strom Thurmond, 47 years. Patrick Leahy, 47 years. This is all in the Senate. Ted Kennedy, 46 years. John Dingell, 59 years. Look at these. I won't go over the specifics, but we're talking 5 decades they've been able to earn money off of their public service. The proposed amendment is simple. Representatives shall serve a maximum of 6 terms, or 12 years, and senators shall serve a maximum of 2 terms, or 12 years. Now, those are the specifics as far as what the resolution should state, as far as specific amendments that the resolution should consider. But let's talk about procedural safeguards. And I've already kind of briefly talked about this when we started this thing off. It's Congress that calls a convention, whether the states vote for it or whether the Congress itself votes for it. It's Congress that calls the convention. Article 5 is silent on the procedures that the convention must follow. State resolutions should include procedural safeguards so Congress doesn't interfere with this process. And I'll just throw this out there. What if there aren't procedural safeguards? What if Congress does set procedures that we find egregious? What do you think the outcome would be and the kind of uproar we would have? I mean, we already have some unrest right now in our country and some disagreements. Imagine what that would be. First of all, and this is a scary one, the convention must specify that it has equal participation and representation for all states. As with the Senate, each state should have 2 delegates appointed by the state's legislature for a total of 100 delegates. What if Congress were to apportion representation based on population? New York, California, insert your other populous states in there, they would have more delegates than, for example, Kansas. That would be unacceptable. Can you imagine, especially when you get some of these enclaves, I won't use the L word, but these enclaves have no respect for the Second Amendment. They have no respect for the freedom of religion. What do you think would happen to the First Amendment and the Second Amendment if those parties had more control and sway and influence over the convention? I think we should try to avoid that. Also, if a sufficient number of petitioning states recall their delegates, let's say the delegates start to discuss things that their actual state legislatures didn't authorize. Well, the problem is the convention is still seated. So there needs to be a safeguard where if a sufficient number of those delegates are recalled and it falls below the 2/3 that voted for the convention in the first place, it should be disbanded and the convention process should start over. That safeguard needs to be within the resolution. Also, the convention should continue deliberations until it considers and votes on all amendments proposed by the resolution. And it may not consider amendments that are not expressly proposed by the resolution. It cannot run away. If the resolution specifies it, it cannot run away from its mandate. That is a safeguard that we must insist on. To summarize this, and we will have time for some questions, that's good. To summarize this, we need a balanced budget amendment. We need an amendment that defines commerce and interstate commerce. We need an amendment that eliminates the power to tax and spend for the general welfare. We need an amendment appealing the 17th Amendment. This is the most important, by the way. I think of all the things, if you could repeal the 17th Amendment, that would take care of, and I used appeal, it's repeal. Repealing the 17th Amendment, that would be the most important and have the most dramatic impact. We need an amendment giving Congress the power to check the court via supermajority votes in both houses. We need an amendment setting term limits in both houses of Congress. And finally, the resolution should specify procedures so Congress doesn't specify the procedures for it. So those are my proposals. And again, there are a few things that I left out so we would have time, hopefully, for questions. Here's the paper. If you want me to send a PDF copy of the entire paper, it's got a lot more specificity within its footnotes. I'm more than happy to do that. But how about some questions? Any questions?
Kevin, thanks. You left out one little thing that thanks for important. The ultimate safeguard is that every amendment has to be ratified by the states by the same process that any other amendment has to be ratified by the states. Now, I have another one for you that you might want to put on your list. Think about it, please. I think that we've come to the point where the Attorney General of the United States needs to be elected, and possibly by the states.
Okay. Well, on your first one, that's in Article 5. 3/5 of the states have to ratify. So that's automatic. And I do include in the safeguards that every amendment that's proposed by the convention should make it through that ratification vote. In other words, not wait till they all get approved, but with each individual proposed amendment making it through the convention, that should be voted on by the state. So I agree with that. As far as Attorney General, I'm not sure about that. Maybe there needs to be something built in the Constitution that gives the power to impeach, for example, anybody who's part of the executive branch a little more easily. That's not the president. I don't know, but the problem is that's also a problem with the separation of powers. We have. And we experienced this when President Trump was in office. We have three branches of government. You have Congress, the executive branch, and the courts. And the idea that we can, interfere with the executive branch, whether it's through legislative or the judicial system, is a little bit disturbing. It's one thing to interfere with the actions that they take. It's another thing to say, I don't like what you're doing, so I'm going to get rid of you or get rid of your appointees. So. I'm not sure about that, but that's something that I think we need to be real careful about.
Two quickies. When you mentioned the Constitution, the Bill of Rights wasn't in the Constitution. And then the other thing, so my question really is, when you talk about there is limits when it comes to raising the budget, if we raise the, and you say, but that's still a limit or a limitation, but it's not if it's raised every year. So I don't get that logic as far as you saying, but that's a limit. I don't consider that a limit.
Okay. Well, I'll just say that if you don't have a balanced budget amendment, you'll never have a balanced budget. Anybody think our Congress will ever balance the budget again? It's not going to happen. I understand, but an amendment would allow us to force them and hold their feet to the fire. The big problem there is the emergency thing. For example, in Kansas, guess what? We kind of have that with public school funding. And guess who, even though it's in the Constitution that it's the legislature that sets budgets, guess what happens when the Supreme Court disagrees with how the legislature sets budgets? Well, they find that they've violated their own Constitution. So there needs to be a limit on a balanced budget where it's not the Supreme Court that sets the terms for the limit. It's first of all the amendment, and then second, it's Congress that has to comply with that requirement. And anyway, the question?
Yeah, when we sign the petitions that go around to say, do we want to have convention of states be voted on in the state of Kansas, does it include all of the recommendations that you're adding into it, or is it not have those in it?
No.
I think it's a little bit confusing on what people are signing versus what some of the things that you're thinking we should have in there, or are we going to decide all that at a later time?
Well, it doesn't. It doesn't contain those three things. The one resolution that's going around involves three pillars. One is balanced budget amendment. Two is term limits. Three is limit the power and jurisdiction of the federal government. And my whole proposition is that third one is the one that contains some possible problems with the possible runaway convention. And again, it also doesn't contain procedural limitations. And if it's not in there, if you look at Article 5, since it's silent, we could see Congress cramming down those policies and procedures. So that's the fear. The fear is that without some sort of change, we would have a problem. I think Chuck wants to say something. He's anxious.
I think that's why a lot of people don't want to sign it, is because of that question mark about what could be added in, at a later time.
Yeah, sorry. So as far as what you're saying, Gary, is so in that resolution that we reviewed here, so the amendment process is
Use
the
the
way
microphone.
Oh, sorry. Is it on? So with that resolution the resolution is basically it's a topic resolution for Convention of States for an Article 5. It's not a specific amendment. Now what Judge Smith here has come up with is lines up to those things, right? So the whole point is when the states get together, any of those proposals, like I've actually seen other people propose similar things that Judge Smith has said. I think even Mark Levin has a few in his book, Liberty Amendments. I saw similar. So these things would be discussed in the states, because really all the convention is, it's a convention of proposals for amendments. This is what this is. Now there has been other Article 5s like the balanced budget, and I think Kansas passed that back, I think it was 79, 80, somewhere in there. And it's still on the books. That was a specific amendment, only one amendment. But the way, the folks with Convention of States looked at it is, one amendment isn't enough anymore with our country and our government. So if we're going to go to the time to do this, let's do it where we can really make a difference. Like everything that Judge Smith brought up here is 17th Amendment, those kind of things. These things can be brought up during the convention. And that's one thing, like you said, when you don't see it in the specific resolution that our state's looking at, and other states, it's specifically any of those things that he's talking about during the convention. Because it's really a convention of proposals. Anything that comes out of the convention, like we talked about, per Article 5, it's still got to go back to the states to ratify. And you still got to have, 3/4 of the states to ratify any amendment. So those are those safeguards. Going back to the Congress and the procedures, and you're right, Article 5 doesn't say, it just says they will call the time and place, basically, where they're going to have it. And I guess what you're saying is that's an open-ended thing, and Congress could just say, hey, we'll call it, but hey, you're going to have to follow this. So, and I would suspect if that happened.
What's your question, sir?
Where's the question?
Yeah, I'm getting to it. I'm sorry. I wanted to address what we were talking about with that confusion with the thing, but the whole point with that what I'm asking is, so if Congress, and just so I understand and get a confirmation, is you're saying that is the worry that Congress could just slip that in, and it could possibly, somebody would question that and it would go to the Supreme Court, and in your mind is we can't trust the Supreme Court even because they're part of the problem, right?
Yeah, not for the, for example, let me give you an example, Chuck.
Yeah.
probably the biggest concern I have is if, let's say, for example, they select delegates based on apportionment, like the House of Representatives is. That means Congress, in their procedures, if they determine that the number of delegates sent are apportioned according to the population within the states, guess what states are not going to get equal representation? It'll be the conservative state.
They would not have a convention, so one vote for one state. It's all the way.
That's not in Article 5. So I appreciate what you're saying, but that's not in Article 5. Article 5 is silent to that. Article 5 is silent on that.
That's the way all conventions have been held.
There's never been a convention of the states, Chuck.
Interstate convention of other states, they've had many.
I understand that, but
they've always followed the same.
Chuck, it's the federal Constitution that controls a federal convention.
Sounds to me like we have a runaway constitution right now. So we can't agree on anything right here in this group.
Right.
Basically, what does the Constitutional Convention would do? I don't have any trust in the whole process, basically. With the type of people we get. I happen to agree with Antonio Scalia's his comments, basically, about that you presented earlier. The question is, what is the status of the Constitutional Convention in Kansas, basically? And I understand there's some playing with some of the rules, basically, that might be able to make it.
You know what? I think Representative Humphreys should talk about this issue. Actually, there's been some misinformation about them trying to play with the rules to allow a majority of the House to vote for a resolution, but.
So with the permission of the Speaker and the rules, so I do think there's been a lot of misinformation about what we just did in the House this last week. Yesterday, Wednesday and Thursday actually. So at the beginning of every term, we have House rules that we pass, and we also have joint rules with the Senate that we pass. And there was a lot of people emailing us, for weeks, about change the House rules to say that it just needs to be a simple majority to ask for a convention of states. Our House rules going into this session said it needs to be 2/3. So what we did, just so everyone is very clear and understands this, because it's hard to understand. What we ended up doing, we did change the rules, and what we said in the House rules was to call a convention of states in Kansas, you need to look to the Kansas Constitution. What did they say we need to have?
Right.
And that's 2/3. And so the Senate says 2/3 you need to call. Now the House and the Senate say the same thing. And that was for consistency, and it was for clarity, because it's confusing. There's a report out there, opinion by Derek Smith that said, well, maybe the Kansas Constitution usurps the federal Constitution and so on. It's only an opinion. No matter where you stand on Convention of States for or against, it's better to have clarity with our House rules. And our House rules now just point to the Kansas Constitution. So we did change them, but we changed them to just say 2/3 like the Kansas Constitution. So just so everyone is clear, and when I get emails from you, you'll know what happened. So thank you.
So I'm neither for nor against the Convention of States, and I've heard all of it. What I want to thank the judge for is bringing up the facts that no matter if we have a convention or not, what's going to determine what comes out of it are the rules. And if the rules are not very clear, then it could be a runaway. So I thank you for putting up all of your points, because just to have some I personally like laws to be very limited in what they say, like the Constitution is very limited. However, we know how people work in this country, and we've got people that do not want our values to continue. If we have a Constitution of States and the rules are not extremely clear and very specific, it could be a runaway, and I think it would be a runaway. So thank you.
And I want to be clear. I see Chuck glaring at me right now. I want to be clear. We need a convention of the states, because Congress will never propose anything, vote on anything that limits the federal government. But we also need a resolution that's more than just a general setup, but basically says this, 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 and this. It needs to be constrained. That's all I'm saying. And I've laid out some issues. For example, you could pass a resolution that only says repeal the 17th Amendment. Now that's probably going to not make it past the ratification process, but that is certainly a worthy goal because I think that's the biggest problem we have. But it needs to specify, again, just the issues I've stated: Commerce Clause, tax and spend for the general welfare, repeal the 17th, balanced budget, term limits. It needs to be specific as to at least those issues, and of course, throw in the legislature having the ability to overturn the Supreme Court. So, Dr. Eddy.
Yeah, so Judge, you know, in the city of Wichita, owning the marijuana is decriminalized, but the legislation says the opposite. Who should you follow? The city of Wichita or the legislature?
I think the state preempts that. So if marijuana is illegal in the entire state of Kansas, then I don't think municipalities should be able to not enforce those laws. But what do? I mean, you're going to have the county. I think Sheriff Easter was here and talked about how difficult that is. They just and DA Bennett did the same thing. It's impossible. They don't have enough manpower. So if the city decides to just step back and not enforce the law, then that could be problematic. So I don't know. But state law should preempt, seems to me.
Okay, with all due respect,
I'm about to get in trouble, by the way.
but with all due respect, Senator, or Representative Humphreys, in your committee testimony or in the committee discussion, you did say that the change was made for the sake of dealing with a lawsuit. Now, I think it's reasonable to presume that that lawsuit would be one of the kind of lawsuits that was discussed in the Attorney General's paper. And I'm getting to my question, I am. But in the Attorney General's paper, the discussion is summarized by the Attorney General's statement saying that this process of calling for a convention of states, quote, cannot be constrained by the people of Kansas, end quote. And he was talking specifically about the constraints placed by Article 2, Section 13 of the Kansas Constitution, which specifically gives that 2/3 requirement. So he was saying that's only precatory, which is a word I had to look up. And it means it's only a wish of the people of Kansas when the Kansas legislature is dealing directly with the federal government. So in this case, the Kansas Constitution and the people of Kansas don't count. We don't count. We have no constraints on the process. So my question about your constraints that you would place on the convention, my question is, under what jurisdiction would those constraints be made? And this is the catch-22 to that question, because if you answer under the federal jurisdiction, then they do have an impact, but they're going to be created. Those constraints won't pass, and if they are passed, they won't be the kind of constraints we want. That's in the state jurisdiction.
Well, hold on.
No
That's an easy answer. It's the people. It's the people that are calling the convention under a convention of the states. It's not the federal government. It's not the state governments. It's the people. The people are calling for the convention. They are the ones, if you have a very specific resolution, they are the ones that limit the ability of the convention to go off the rails. It's the people, and the people should be the ones that control this process.
Thank you for being here today. So, Article 6 gives the supremacy clause.
Yeah.
How does the 10th Amendment, which I think directly relates to this question.
Can't hear you.
The 10th Amendment, how does that directly relate with the supremacy clause of Article 6? Does the 10th Amendment give the Kansas Constitution equal footing with Article 6 and 213 of the Kansas Constitution?
I'll just say generally the 10th Amendment reserves to the states any non-enumerated power, but that's the problem with this process. We no longer have just enumerated powers. We have powers that expand so far beyond enumerated powers that you really can't determine if one legislative enactment to another is going to be found constitutional, because the enumerated powers are spelled out. And it's all these other things, like, for example, substantially affect interstate commerce, these additional definitions that the court has made that expand it ad infinitum. So again, technically, the Kansas Constitution should step up when it comes to health and welfare of the citizens within their state borders. But through the Commerce Clause, tax and spend for the general welfare, these other things we've discussed, the Supreme Court has expanded that beyond the enumerated powers.
Yeah, I don't have any problems with the Constitution. Seems to me we're trying to regulate people with low integrity. So is there any way?
No.
Can you make the Constitution or the amendment be that the original intent of the law is to be followed? Not what they deem it to be today, but what was the original intent when the law was formed?
Well, and that's kind of, you know, if you're a student of the Constitution, you know that's what these proposals are. That's what they are. The problem is, like you said, you get people that aren't of great character. They're going to expand things to mean things that benefits them and doesn't necessarily benefit the people, and results in a more centralized government that presses down on our rights. So that's a good question.
Judge Kevin Smith, we've got